Sir, and welcome
Good
to
evening.
the Vidhisamvad, a podcast initiative from Project Nyay. I thank you on behalf of the whole team to be here and to give us an opportunity to host you for this podcast session.
I'm very much obliged to be part of this podcast. Same here.
So, sir, first question would sound very generic, but I'll still begin with what
Please.
inspired you to pursue legal studies in the first place?
I so knew this question was coming anyway. See, there was no specific reason that I mean, because of which I started. But yes, obviously, everyone admires courtroom dramas, uh, all such things, obviously. Everyone loves suits. And personally, I like one of the very not so renowned courtroom dramas, one being Boston Legal. That was way back. In obviously in 2000 that came in. But yes, that was one of the inspirations that I always wanted to get into law and understand how this field works. Yes.
Sir, so is there some inspiration from Devil's Advocate and Justice for All too?
Frankly, I haven't seen any of those, so I can't really comment on that.
Okay, sir, sure, sir. So, next thing, while being in college, while being in GGS IPU, were
Mhm.
you all-rounder student who went for moot court competitions and other competitions as well, or were you more academic focused?
I was actually very contrary. I was not at all attentive in college. I'll be very frank. I was one of those students who just used to, just wanted to enjoy those college life for 5 years. I merely participated in moot courts, but yes, I did participate in client counseling, and I was not so very good at academics. It is only after when I graduated from the college, it actually came into me that yes, actually, I need to do something. So yes, I was not really a very bright student in my college days.
So, basically, client counseling explains your interest in the field of arbitration more and more.
You can say that. You can say that. Yeah.
So, nowadays we see a very sharp trend towards moot court competitions from a lot
Hmm.
of colleges all over India.
Yeah.
And very recently we saw a video which was from a high court. I think it was the Jharkhand High Court.
Hmm.
The judges were pretty concerned about the moot court trend actually. So
Yeah, even I
you
saw
must
that.
have
Yeah.
also seen it where he
Yeah.
calls it that is the hazards of moot courts particularly. So how do you think that moot courts affect real life performances in some way?
See, moot courts are very different from what actually the litigation is, what I see from. Because in moot courts there is the drafting is very different from what we actually do in courts. So maybe that must be the reason that the judges or the honorable judges obviously see it in a way that obviously it's not in a manner that is supposed to be, right? And obviously, see, for performance-based understanding, obviously moot courts are really important. If at all you as a person wants to go out and argue, moot courts are very important for you. However, there is a requirement of a streamlining process for moot courts, right? Which has to adhere to the actual norms which are actually followed in courts. So that the gap between what is actually being done in moot courts and what actually happens in courts, lessens. This gap needs to lessen.
So if we were to lessen this gap tomorrow and we would
Hmm,
ask you for
hmm.
a suggestion, what is that one thing that you would like to see in moot court practices which is not there currently but could be introduced and would enhance the performance on a real life basis?
See, in any case, drafting is the king, right? It has to be streamlined in a manner that it adheres to the norms that are specified by the court itself. Like there are high court rules, there are specific rules. The moot court competition could actually introduce that, saying that it has to be adhered in a manner the high court has provided, which would essentially help the students itself to know what the drafting is from even before the start of their own career. So that's very important because what happens in moot courts, there is a type of drafting that's been provided there in the moot court competition manual or booklet, which is completely different from what is actually adhered in courts. So if at all a trend could actually, come in, wherein what is being provided in the high court rules, or for that matter, any court rules, what drafting should be, that should also be imbibed in the moot courts competition.
So also being like a first year student, what I usually say is the way we practice moot courts right now is like very Victorian in the sense. Jabki real life courts are not the same as the moot courts, because we usually go, we are
Yeah.
more like your lordships this, your lordships. And even in some higher courts, there are some advocates who are very fluent with both the languages, but would still go about it in a casual, yet in a very formal way. So summing your conversation up, that drafting is one of the things which is
Drafting is the
really
king.
necessary.
So how you present your case, because see, if at all you present your case right, you would be able to argue it much better. If you know what you've written, you would know what to argue. And that's very important. And I feel like that's what is missing.
So also we've seen that you've completed your LLM from NLUJ, which is like a
Yeah.
dream for a lot of CLAT pursuing students for now.
Yeah.
So one thing, how was your experience at National Law University, Jodhpur, while doing
See,
your
my
LLM?
experience was very limited. That was not more than a year anyway, obviously. In my limited experience, uh, it was really good. See, I could really understand a new perspective as to how do I need to, you know, study law? How do I need to understand a particular law? So I could really, so since obviously I was not a very great student in my 5 year college, I tried to, do good in CLAT, and obviously, thankfully, I got NLU Jodhpur, and because of which I actually able to understand law much better in different ways. It's not actually book learning; it's actually experience. It's actually going through the judgments, reading them, understanding them. There's a Hindi word called manthan karna, to understand in one inside. Okay, if at all there is something, the law says this, how can you circumvent it? How can you, you know, do something which might not also affect the law, but also works in your favor? How to process it? That's very important. That's a very important facet that I could actually learn while I was in NLU Jodhpur.
So also being a law student after completing your graduation LLM, now
Hmm.
what we see recently is there is an increase of people wanting to learn the law in India, which was not
Hmm.
there previously. More people were more interested in engineering, agriculture, and
Hmm.
medical field. So being a law student and being a lawyer, how do you see this? How do you perceive this particular trend, and how proud do you feel about this particular situation?
See, I would say that this trend of people wanting to do law is more related to money. I'm assuming. I'm not sure. I've not done my survey, but they're related to more in terms of monetary understanding. However, for me, it's very different. It really depends on what makes you feel happy or what makes you feel satisfied. Like money can definitely be, the reason for your satisfaction, but it entirely depends on what you perceive of it. For me, it's always not the money, it's always me going to the court and arguing. It's a different adrenaline rush. In the beginning, you might not be earning that much if at all you were in a law firm. If you juxtapose the situation of you actually going and arguing with getting into a good law firm and earning lakhs of rupees, is very different. You can be a person who would want to go to a tier one law firm, earn lakhs of rupees, you know, be the best person there. But contrary to the same, there is something called arguing, which might not get you so much money, but can get you that satisfaction. So it really depends on person to person as to what they perceive of it and how they look at it as a obviously law profession.
Also like being a more recent student of law, what I usually see is there is a change of trend from I'm doing this degree because I don't want to study, to
Hmm.
I want to do this degree because I'm good at speaking and I want to argue. So how do
Hmm.
you also see this particular situation? What's your perspective on this one?
So I didn't understand how what the
People before, people used to do law because they were more like,
hmm.
because I don't want to study anything, so why not do law? Anyways, I don't have to do a lot. Nowadays, people are
Okay.
towards law more because they are like, I want to argue. I want to go into corporates, I want to go to the court. So how do you see this particular change in the mindset or the mentality of people?
See, I think the very question that you begin with is something matlab, that's this understanding of people saying that I don't want to study, that's why I'm doing law, is absolutely incorrect. Why? Because if you're getting into law, you should know, in fact, that for your entire life you have to study, right? So this is a clear misconception of people of actually trying to understand, oh, मैं तो लॉ कर लेता हूँ मुझे पढ़ना नहीं पड़ेगा. But it's actually opposite, right? While juxtaposing this situation to people who really want to study law for doing what they want is something that is something which is more relevant. People doing law only for the sake of it is obviously not solving no purpose, but people having purpose for doing law is something which is very relevant.
So going back to one of my previous questions,
Yes.
nowadays there is also one type of mindset that is being propagated among students, which is usually you do LLM only when you
Hmm.
want to teach. This is the kind of mindset which is being
Hmm.
propagated more recently, because I've heard it from a
Yeah.
lot of seniors and a lot of students around me. So, what is your say on this particular sentence?
See, I would agree to some extent, but I would disagree also. Why I agree on this is fact because see, if at all you really want to pursue LLM, you're actually going towards the path of being a professor into a teaching profession because a teaching profession mandatorily requires for you to have an LLM degree, right? And as a litigation, if at all you want to get into litigation, then there is no need for doing LLM because you would waste that 1 year of your experience if you get into LLM, right? And if at all you want to get into the market, do the litigation, then doing LLM is of no use. But yes, if at all, why I agree also is that if at all you want to do LLM to expand your knowledge, then you should definitely do it and then get into litigation. That's absolutely up to you as to why do you need to do LLM or not. That's why I'm saying I agree also, but I disagree also. So I have different perspective in both the understanding.
So, what was your particular reason to do LLM?
See, my reason was to obviously expand my knowledge in that particular field. So I did masters in corporate laws from NLU Jodhpur. I really wanted to understand. I really wanted to have a broader perspective in that arena. That's why I did LLM, and obviously I wanted to have an exposure of how an NLU functions or how the teachings are happening in NLU as compared to how it happens in other universities. These were the two main reasons as to why I did LLM and obviously from an NLU.
So, also congratulations on crossing 17K followers on Instagram.
Oh, thank you so much.
And
Thank you.
there was one question that we were all curious about: the
Hmm.
story behind Vakeel next door ka name.
Behind the name, acha, behind the name.
Yes, sir.
So I made a lot of videos. Like I made 10 to 12 videos already, and I was like, what name should I give? So one of my colleagues actually helped me. Why not make it very simple and sound that any person who's very approachable, any lawyer who's very approachable. So he suggested me make it next door Vakeel. And I was like, it's not sounding right. Why not Vakeel next door? And it actually came into mind, oh yes, this is the right name. And I immediately put that username on my Instagram and I started the channel. So this happened instantly. It was nothing pre-planned. My only idea was for the name was that it should be very easily to catch and it's something which humanizes me as a lawyer. Because the problem is that people think that lawyers are very, you know, you have attitude problem. Lawyers are very, entitled people. Lawyers are very, uh, I mean, they have some attitude problems. They have a certain demeanor which people do not like. So I wanted to keep it in a way that it humanizes it and it fits in a manner that it is approachable to people. So that was the idea for the username, and obviously my friends suggested next door Vakeel, and I was like, oh no, why? Let's make it Vakeel next door. So I did it.
So, one of the now moving towards the legal field a little.
Yes.
Being a lawyer, how do you deal with the question of conscience? Because it's not always that our client is right. Sometimes you know the
Hmm.
original story. So, how do you keep aside your conscience while dealing with the case?
See, it really depends on case to case basis. Obviously, as a professional, you would also you need because there are professional ethics, and you would have to represent your client to the best of your abilities. Even though we know, see, everything is not white and black in a situation. Even if you're fighting for a particular person who might be a criminal in the eyes of law, but there might be also situations which would show that he is not the criminal in that particular offense, because it has to first satisfy those ingredients of that particular offense to actually come to an understanding that he has actually committed that offense, right? So everything is not entirely black or white. That person could be assuming that this person has been charged with murder, but you might know that all the ingredients of murder are not coming through. Then you would, as a lawyer, have to argue to say that he can't be charged for murder, but he could be charged for another offense, which is not murder, because none of the ingredients mentioned in the code are present. So you can't really charge this person of murder. So it really depends on case to case basis. So as a lawyer, you have to protect your client to the best of your abilities, obviously. And obviously, like as an officer of the court, we're considered as officer of the court, you would have to put the truth in front of the judge. And while doing that, you are supposed to obviously help your client, be truthful to yourself, be truthful to the court, be truthful to your colleagues, your opposite side, right? Which is very important.
So, among all of this, how do you stay truthful to your own ethics?
Being truthful to your own ethics, see, I know if at all a person has committed murder, but for me to be truthful to my ethics, I have to, present the case in a manner that I should complete bona fides of that person and leave it to the court to decide. See, for me, it is an experience that obviously helped me grow. And why should I not use that experience maybe later? Because if at all I would say no, I would not take this client, then any person in this profession would say he would not want to take his client, right? As a professional, as a officer of the court, the conscious definitely comes into the picture. But you would have to understand the bigger picture, which is obviously how can you do best for your client even though he's wrong. As a professional, you would have to put straightforward to the court, yes, he's guilty, but he's not guilty of this. And then you leave it to the judgment of the court. It is ultimately to your own satisfaction that you tried your best, right? And that what actually matters, even despite of the fact, even in fact, in light of the fact that you know that he's wrong. He's wrong. You say to the court that he's wrong, but he's not absolutely wrong. So it really depends on each case to case basis. You can't just say today कि नहीं भाई इसने मर्डर किया है मैं इसका केस ही नहीं लूंगा. You first need to understand कि यार उसका केस है क्या. तभी तो मैं डिसाइड कर पाऊंगा, बिकॉज माई कॉन्शियस नीड्स टू बी फर्स्ट क्लियर कि मैं उसका केस राइटली प्रेजेंट भी कर पाऊंगा नहीं कर पाऊंगा. मान लो उसने सिर्फ ग्रीवियस हर्ट किया है या सिर्फ अटेम्प्ट टू मर्डर ही किया है और मर्डर किया ही नहीं था, तो वो मर्डर अटेम्प्ट टू मर्डर के लिए वो गिल्टी है, बट मर्डर के लिए तो नहीं है ना. इन दैट सिनेरियो आपने मर्डर के लिए तो उससे बचा लिया, बट वो अटेम्प्ट टू मर्डर के लिए तो गिल्टी है ही. वहां आपकी कॉन्शियस हेल्प करेगी टू सेव दैट पर्सन फ्रॉम मर्डर, बट ही इज ऑब्वियसली चार्ज फॉर मर्डर. तो मर्डर तो कमिट हुआ ही ना, अटेम्प्ट टू मर्डर तो हुआ ही ना.
So, also we saw that one of the main seasons of India just commenced recently, which was the election season. And in light of your reel where you were explaining ki, how does
Hmm.
EVMs work actually? So nowadays,
Yeah.
sir, we also see a trend of people demanding the traditional ballot paper system
Hmm.
before the EVM
Hmm.
system. But the question which arises is in an era of digitalization where we are trying to move towards
Hmm.
digitalized ways, why do people want to move to the traditional methods of ballots and papers, and How do you see this particular situation?
See, what I think is why people want it into a ballot system is because it has more accuracy. Obviously, there is always a chance of error. Why people would want ballot paper would be that it is more accurate as compared to machines, because machines could anyway at the end of the day could be tampered, right? But the ballot papers cannot be tampered, right? Whenever you put a ballot paper, you put in a sealed box, and that's the end, and that will be only open on the day when the votes are being counted, right? However, EVMs can, become malfunction. EVMs, may be able to, get tampered. Obviously, those are electronic machines. Those can be tampered any day. That's why maybe people have that understanding as to why ballot paper should be banned. But this actually has been taken care by EVMs also. How? Because there is always a VVPAT that's also attached with the EVMs. Now that VVPAT is called Voter Verified Paper Audit Trail, right? Those are always attached with the EVMs. So whenever you punch in your vote, that EVM generates a slip in VVPAT, which is shown to the candidate for 7 seconds, which actually shows that yes, you've voted for this particular candidate. Just to show that there are free and fair elections that are happening and whatever you have voted is absolutely correct. So that actually also solves the purpose of ballot issue, because these, whenever are generated, they directly go into a sealed box and they're stored. And if at all there is any discrepancy in whatever is coming on the EVM, it can be solved by that VVPAT slips. That's why it is called voter verified paper audit trail. So whenever a returning officer, or for that matter, any person who's concerned with the election process wants to verify those details, he could definitely go back to those VVPAT slips, because those are very important at the end of the day. So it really solves the purpose of ballot paper. And while that's happening, and it also solves the purpose because electronic voting machines are there, it helps in speedy process of take a declaration of results.
Exactly. Because the thing is that EVMs, calculating votes through EVMs would be a lot easier because it's computerized,
Yes.
and also because with growing times, India is casting more and more votes every day. So,
Hmm.
that kind of is still a confusing question when it comes to you. But personally, what would you prefer for voting? Ballot paper, EVM?
No, I would prefer EVM any day, because now since there is a voter verified paper audit trail system along with it, why would anyone want to go back to that ballot paper understanding? Because anyone could go and maybe take a paper, make a mark or something, or do something which would obviously uh, make the entire thing very inconsequential. So in fact, obviously, when you punch something on the EVM, that's much better, and a slip is generated, which would obviously show that you have voted. So that's much better as compared to obviously ballots.
So also talking about digitalization, we usually
Hmm.
see that the post-COVID era for both the Supreme Court and a lot of courts in India is a digital era. So
Hmm.
how do you see this growth? And being a lawyer, what kind of problems do you encounter on a daily basis with this digitalized platform?
See, I am happy with this digitalization method also, because assuming I have 10 cases in a day and I would not be able to reach at every case on each time, I'm able to use that electronic technology, obviously video, to actually say that my lords may pass this matter because I'm running into this code and that code. Or maybe, if at all I'm not well, I could sit at my convenience from my home and do that hearing. That really helps in that understanding. However, in a situation, if you know that a particular judge is someone who would prefer for you to come physically argue, and you know that before that judge, if you'd argue physically, that would be more impactful, you would want to go physically and not appear online, right? So, if at all in that case you are appearing online and the judge is of a disposition that, yes, obviously, I want someone to convince me in physically, that might not be the best scenario for you, for your client, in fact. So there are situations, obviously, which favors a physical hearing, but obviously, as a person, you as a lawyer, you it benefits you because online hearings are something which helps you make it more convenient as a lawyer.
So just to sum up, even though digital methods are making things convenient, but it still affects the convincing power related to
It
the
might,
case.
it does sometimes because a judge might hear you better in person as compared to video conferencing. Though I'm saying, assuming everything is fine, this all video conferencing system are absolutely in place. There is no internet lagging issue, but ultimately, sometimes really what happens is that your physical presence really matters in court.
So, with this statement, we can also say that no matter how much digitalized we make the scenario of legal hearings, it's still difficult to replace the traditional methods of appearing in courts.
I would not entirely agree to that, obviously, because since it's more of a convenience understanding, because assuming that's a case that's not in Delhi, I'm working profession in Delhi, and I have to appear in a court which is not in Delhi and maybe in Chandigarh or maybe in South. I could appear online and obviously, help my client. Right. So it is convenient in that scenario also. So it has its both pros and cons. I would not entirely agree on the fact that yes, more ways of going to the court physically are better. But I'm also not with the fact that yes, absolutely online hearings are also much better. Right. So it entirely depends on before which judge you are actually appearing.
So with digitalization, what kind of developments and drawbacks do you see while dealing with competition matters? Since you're more into the field of dealing with competition matters.
See, competition matters are done completely online. I have never seen a case like in my career, I haven't seen a single case which has not been dealt online. Competition cases are done completely virtual, like hearings. I'm not on depositions, I'm not on evidence recording. I'm only on the fact when a cross examination is done or when a final hearing is conducted. These are always done online. Say, obviously, since I've started doing, till the time I've started doing competition law, those are absolutely done online. Like before the Competition Commission of India, if it all is before the NCLAT, you go to the court physically. That's very different. It depends on case to case, but however, I've seen all competition cases before the CCI online. I could see no challenge. I mean, because the chairman, the members of the competition commission are very much aware of, that these are supposed to go online. I don't feel there's any challenge per se, apart from the internet connectivity issues that may persist or that may come. I don't see any challenge.
So also, as we see that you prefer arbitration, and how do you convince your clients to let go of their ego and try to solve a matter through arbitration, mediation, or negotiation nowadays?
Arbitration is again a process that's a that's entirely another type of court, wherein an arbitrator is appointed who adjudicates into the disputes, which has all the powers of a civil court. Essentially, I we definitely tell them that obviously, see, there is always a time value of money. We might have to convince the client to say, see, okay, आपको इतना time लगेगा आपके dispute में और आप इतना पैसा lose कर सकते हैं because entirely arbitration में क्या होता है? It's money, more of money. मीडिएशन में भी क्या होता है मीडिएशन अगर उसमें चल रही है मैट्रिमोनियल डिस्प्यूट में चल रही है then you could obviously say you lose on the time if you do mediation today you might be able to resolve it today and hence that period can be waived off, so to say. It's like buying peace. It's like buying peace from that money if at all a mediation is coming to a mediation is actually fructifying. So obviously we try to make every client understand if at all they really want to resolve a dispute amicably. And in fact, the courts are also of the opinion that you should go and mediate. That's why we try and convince our client that you need to understand time value of money. If you want to see 10 years of life in litigation, please go ahead. We are okay with it. However, if you want to see it settling today, why not go for mediation?
Also, looking at your interest in matrimonial matters, particularly not very recently, but like an year or more than a year ago, the Supreme Court passed a judgment where they allowed the LGBTQ community people to live together, but not marriage. So now the
Hmm.
thing is, us being law students, we understand that why did the court not give a judgment for marriage, but there are
Hmm.
a lot of non-law audience who have a lot of activism. So if you could
Hmm.
kindly explain why Supreme Court could not a judgment in relation to LGBTQ community allowed to being married, or why?
Hmm. See, I'll tell you what I could take off from that understanding were two things. One is that in India, a marriage is considered as a sacramental union between a male and a female. If at all they change that dynamics, it would wither away the basis of how sacramental a marriage is. Secondly, all the laws, matrimonial laws, are based on one understanding that a, there is a wife and there is a husband, right? And all the litigation in a matrimonial understanding arises from such relationship of marriage between a man and a female. For instance, domestic violence, for instance, maintenance proceedings, for instance, guardianship petitions. Like, so in that scenario, if at all today, if that understanding changes, assuming that the court allows that a man and a man or a female to get married, then those laws, very laws of maintenance, of guardianship, of domestic violence, has to be completely transformed. It has to undergo a complete transformation for which the country is not ready. Because I'll just tell you, for instance, like a male person cannot adopt, a single male cannot adopt a girl child of a particular age. I'm forgetting the exact age, right? So if at all there is no husband or wife, they can, and there is only husband and husband, he cannot adopt a child who's a female child. And hence it requires a complete transformation of that law then. So that's actually the understanding.
So also for domestic violence cases, how
Hmm.
does the appearance of LGBTQ couple relationships affect the whole dynamics of domestic violence? Because basically, what domestic violence actually is, it's from a male to a female through economical, mental, or physical stress. But due to the sudden rise of LGBTQ couple relationships recently, how do you think these particular dynamics are affected? And in what manner should the law be formulated to accommodate every single spectrum of people?
See, again, I would say that domestic violence laws are only made for women, right? And it is only to safeguard their interest. And if at all a domestic violence type of concept is introduced for LGBTQ community, I would not really want to comment on it, obviously, but if at all it's been introduced in a way, it would change the entire dynamics. Because tomorrow, if at all two male enter into a relationship, assuming into a marriage, I say that both of the males have the right to file for domestic violence. Who would file against whom? Because both would be in the same footing. I say that he has done domestic violence on me. The other person could say he has done domestic violence on me. Both would go to the court with their domestic violence petitions. How will the court see it? How will the court know that who's correct and who's not? It's very difficult to actually consider. And even otherwise, there are other laws also to protect them. There are laws for defamation. If something verbal has been said in front of a third person, there is defamation. If some physical harm has been done, there is definitely IPC provisions like grievous hurt, anything. So there are already laws in place, but these are the special laws which are provided for weaker section of the society, so to say, which is obviously still considered women. These are specifically for them.
So, also, if you could share your experience about the arbitration case between the construction company and NHI, What is one of the key learnings that you gained from that particular case?
See, that actually helped me to understand how a construction really happens. Like, so we represented one of the construction companies who were developing a highway against NHI. So we were able to understand what all dynamics, what all goes into making a particular road, right? What all material is used, how a construction happens, in what time period it happens, how many tolls are to be there, what toll money needs to be collected, what toll money need not be collected, what could be the instance that if at all there is any emergency on a road, what needs to be done. So you as a lawyer have to live through it to actually understand the case and present to the arbitrator. So in I would say not only arbitration, every case that you do, if you live through it, you would understand those cases better.
Also, congratulations on the landmark judgment towards your side.
Thank you. That's been
Hopefully,
2023, yaar. Purana hai.
so it's still new, sir. 2024 just started. So
Yes.
hopefully, when I'll get to read SEBI law in the future, I'll
Please,
definitely
please.
make sure I tag you on the stories.
Absolutely. That's one of the first very cases of Supreme Court which actually defined the scope of appeal before the Supreme Court in a case decided under SEBI Act. What is the scope till for what in what situations an appeal would lie before the Supreme Court under Section 15Z of the SEBI Act? So yes.
So, also, how does it feel to have a landmark judgment to yourself?
See, it feels really good. Obviously, we never thought it would be. See, that case really popped up because that was a case back of 2009 and it never came. And it suddenly popped up in the court and said, okay, you would have to argue within 2 days because what happens is that the court just updates it on their website. So we get to know immediately, right? So I still remember we were spending, it was after only 2 days. We spent the entire day, the entire night. We didn't sleep for 2 days for that case because there were a lot of things that we need to study before we actually get into that matter and argue. So yes, it was a difficult time, but yes, learning experience, obviously.
Sure, sir. So we are drawing very close to the end of the podcast. Two
Oh
main
wow.
questions. Two
Yes.
main questions. First question,
Yeah.
sir, if you were to go back in time with the same
Hmm.
amount of knowledge you have, so what mistake would you try not making as a legal student?
Yeah, I would try and study more, much better. मतलब ऐसा कुछ नहीं. I would not want to make anything right or wrong. Everyone is at a place where they're supposed to be, and you can't change it. And obviously, I wouldn't want to change even a bit. If at all I would have not been that person in college, I wouldn't have come to NLU Jodhpur. Neither I would have been a person that I'm right now. So it's the journey that's important, not what I should have been back then. Every experience, uh, you know, every experience teaches you something. So that's the experience that taught me that how do I need to, do some mehnat and get into a you know, good NLU, and obviously thereafter leading me to this. If at all I wouldn't have that nag, I wouldn't have done LLM from NLU Jodhpur to begin with. So I don't see that I should go back and change something.
Thank you, sir. So also last question. What are your advice for students who are currently doing law and
Hmm.
also students who are planning on pursuing law, because we are also going to have a lot of non-law audience as per now.
See, for law students, I would say that you should know what you need to do after you graduate as a lawyer. There are various fields because me as a lawyer, it took me actually 3 to 4 years to act after I completed my graduation to understand what I need to do. You as a law student should be very clear what is your forte. Your forte is to argue, you should move towards it. If your forte is drafting, if your forte is going into corporates, if your forte is teaching, or if your forte is to get into a good corporate company or law firm, you should know it better. You should analyze it. You should understand what makes you more feel happy. See, money would eventually come as a lawyer, but what is important is your own satisfaction as a lawyer. And obviously, it requires a lot of perseverance, it requires a lot of hard work, but at the end, it definitely pays off in whatever you do as a law graduate. And anyone who's aspiring to be a lawyer and who's not a lawyer as of yet and who's not got into uh, as a law student, I would say that you would need to understand two things. You have to do hard work and you have to study your whole life. These are the two things that you should know if you're getting into this profession of law. But yes, in the beginning, you would have to, face hardships. But at the end, you would definitely succeed if you are there, if you're still working towards what you really want to do, if you're still standing there.
So, thank you so much, sir, for giving us this opportunity to host you. I once again thank you on behalf of the whole team, and especially the project coordinators, Pawan SS and Kamal Aditya. Thank you for
Thank you
giving
so
us
much.
your time, sir.
Thank you so much. Thank you so much for inviting me. It's been a really uh, enriching experience to be part of this podcast, and looking forward to more if at all there's any.